Today, I wanted to talk about a planning technique that sometimes I think it's underused, but it's an option for our clients. I'm going to share my screen and and show you what I'm talking about. So, can everybody hear me okay? Hope so. So what we're going to talk about is this option for planning for a group of people, where we basically have a certain one fund that's available for all of the beneficiaries. It's typically discretionary, and because we don't know necessarily what the needs of any particular beneficiary might be of that group, we leave it flexible. And it's called a pooled trust. And the idea is you take a group of people, and I'm going to demonstrate in a second for children, and you say, listen, I've got this money. One of my kids might need more than another, or I'm not sure, they're at different stages of life. So I've already paid for education for one and not for the other, and they're going to be educated. And so I don't want to split it into separate amounts immediately on death. Instead, I want to combine the money in one trust for a group of people, and then ultimately maybe divvy it up or not. So let's just show you how you do that in eState. So typically you see this with children. And it's often with the residue. So I'm going to demonstrate it in that situation. So here we are in the descendants only scenario. And we talk to the clients, and they have, one of the three kids, might need more than another kid. But we don't want to treat them necessarily differently, but we want to group that gift. So what we would do here is we'd add a gift, and we'd pick the people that we want to be part of that, have access to that money, that beneficiary. So we could do it by class, or we pick the people. So I'm hoping I can hear people here. I've mixed up my sound. So let's do the three kids are going to be the beneficiaries of this pooled trust. And so it's not an absolute gift, obviously, it's a trust. So it's going to be 100% of the residue. But here under payout, we have two options. The one you've probably always been using or regularly using is the amount divided equally among the beneficiaries. So there's a separate trust for each, what we call internally a separate trust, a gift where each person gets a separate trust. It's siloed, and you can't dip into it from another person. It's for that one person. What we're describing here is a pooled trust. And so we're going to click pooled trust as the payout. Okay. Now, with pooled trusts, we have a bunch of different options. If we're talking about one trust for all of those three beneficiaries, then we would want, we don't want separate pooled trusts. Okay. Separate pooled trust means a single trust for each of the three kids, and for each of those kids, their kids, or their descendants, or their spouse, or a combination thereof. So there would be, in the separate pooled trust for each beneficiary, then I'd have three separate trusts, but I'd include each beneficiary's issue, for example. So Bart and his kids in one trust, Lisa and her kids in one trust, and Maggie and her kids in another trust. So three separate trusts. You see that we used to do that a little bit more when we could split income and all of those things. But so that's what separate pooled trusts mean for each beneficiary. But the example I gave you is one pooled trust for all three beneficiaries. Okay. So we're going to just pick pooled trust. We're not going to select any of these. The duration is going to be the death. Okay. The death of the last of those beneficiaries. Okay. We could do death. We could pick the beneficiaries. So we could say Bart, Lisa, and Maggie. And it's the last to die of that group. Okay. We could do an age. We could do whatever kind of duration you want. But in this case, I'm just giving you an example of, we want this pooled money to be in existence as long as any one of those three is alive. Okay. So that's what we could do. And then that would be the trust. And we'd leave it, typically you leave it discretionary, right? Unlimited discretion. That's what you would do if you said, listen, my client wants access to, or have the kids have access to the money and while they're all alive, okay? Or any of them are alive. It's going to last until that point. Another example of a pooled trust is you hold it until the youngest, instead of dies, or until they're all a certain age, and then you split it, right? I'll demonstrate how you do that, because that's also a common one. So we pick the duration. We're going to pick age of beneficiary. We're going to say, listen, until they're all 30, we're going to hold it. It's not the first beneficiary. It's when all the beneficiaries reach age 30 that this trust is going to end. Okay. And at the end of that trust, we want it split among the beneficiaries that are alive. Okay. And if any of them aren't alive, so sorry, beneficiary first, beneficiaries' children, if they're not alive at that point, otherwise the other beneficiaries. So this kind of trust, and I'm going to show you what that's going to look like, is going to say, hold all this money in one pooled trust until all those kids are 30, and then split it equally among that. And that gives the trustee the access and ability to prefer one child over another if their expenses were more than another. And so I'll just show you the drafting on this in a short will. It's fine. How that will come out. And it'll basically describe that trust. So let me just go down here to this pooled trust. And it's going to say to set aside the residue, and it's going to identify the pooled fund beneficiaries. You might want it who are alive at the survival date. There are other things you could do it who are born within, prior to the pool distribution date. You could do all kinds of things. And then it describes how long it's going to be held. It includes the discretionary payment of income. It describes what happens. Oh, we have a disabled beneficiary. That's why it's doing a Henson trust kind of thing, which is not unusual if you've got a disabled beneficiary. And then the gift over says then divided among those pooled beneficiaries who are alive equally, provided that if any of them aren't alive, it goes to their kids. So that's sort of your pooled trust. And the idea there is, if there's not enough money, one example would be there's not enough money for all three kids independently. If we split it up, each trust would be too small for example, the needs of one of the kids as opposed to the other. And so that's the idea. It gives all of these beneficiaries have access to this money. So that's the idea of a pooled trust. You could have a pooled trust followed by, further trusts. So you say hold it in one pooled trust till they're all at least 25, then split it and hold those in trust till in equal trust, so in separate trusts, until they reach 35 or something. And so you can combine them. And the way you would do that is you would go with a specific distribution and then create whatever kind of trust you wanted to create after the pooled trust. So if it was, a two-stage distribution, something like that, you could do that. We would get rid of all these other ones, and we'd move this up here and say at the end of this pooled trust, then we want a specific distribution. Well, what do we want? We want to split it now into separate trusts for each of the children, into separate trusts. And then we have further trust terms that have to make sense, right? I mean, you're not going to say hold it till all of them are 30 and then have a trust for them to 30. That wouldn't make sense. You'd have to extend this period past that. So that's the idea. You could build in, so there's a good question, Brody. You could build in an agreement or a provision that says, okay, when you split the money, now take into account any provisions that the beneficiary had received, like any more or less that one beneficiary received while it was a pooled trust. you can do that. I think you'd have to sort of manually do that. But it's a good option, actually. That's one we'll build, I think, because it's an option. So sorry, I don't know if my headphones are working. Let me just try doing this. Can you guys hear me now? Michaela, can you hear me?
Yep, I can hear you fine.
Okay, good. Now I can hear you guys. So yeah, not an unusual one where you say, okay, now once we've finished the pool trust, if one kid received more during that period, I want it to be hodgepodged when we're splitting everything else up. So I think you could actually do that in here because you just add a condition, which is deduct prior advances. So you would leave, you might have to redraft it, but you could do that because it doesn't contemplate sort of, it's mostly contemplating pre-death distributions rather than distributions during the pool trust period. I want to just show you what separate pool trusts might look like. So let me just get rid of these here. And so I'm going to add, my client says, listen, I want to do separate trusts for each of my clients, each of my children, I mean, and them and their issue, and leave them as the trustee of their own trust. So we have 3 separate trusts. The beneficiary is the trustee of their particular trust, so they can allocate money to themselves or to their descendants. And I'll just show you kind of how that might work. So I'll just do this, I think. So we're going to pick the beneficiaries. We're going to pick the trust option. We're going to pick pool trust. We're going to pick separate pool trust for each beneficiary. Now we need another beneficiary besides the sole child to be part of this. And so we're going to say their issue and maybe their spouse as well. So now we have a separate trust for each child with their descendants and their spouse. Okay. Now we might want to have the beneficiary themselves be the trustee. So I'm going to just show you how you do that. So we're going to start from scratch and we're going to say, listen, the first thing we want is the beneficiary. Okay. First we want, let's just say, because we have young kids, if we made the beneficiary the sole trustee, Bart would be the sole trustee of his own trust, but he'd be at a young age. We might not want that. Okay. So we're going to probably pick my trustees. Okay. And the condition is, so we're going to add my trustees because we want my trustees to be the trustees until the beneficiary reaches a certain age. So I'm just going to demonstrate how you do that. So we pick who's going to be the trustee of this, the beneficiary themselves, and it's going to be when they reach a certain age. Okay. So when they reach 25, then they become the trustee of their own trust. Okay. Now, the trustees, the executors of the estate, they're going to be the trustees only until Bart reaches 25. Now, you could overlap them and things like that, but they're going to resign and then the beneficiary is going to take over. Okay. So that's what we've got here. We've got my trustees are going to be the trustees of each trust until the beneficiary themselves reaches 25, and then the beneficiary is going to take over. Okay. So that's what we've got there. The duration of these pool trusts always lasts until the death of the main beneficiary. So that's that. And then we'll just do this. So this would be that kind of separate pool trust for each kid. So I'm just going to demonstrate what that might look like here. And we actually see that planning more frequently actually in other jurisdictions than in Ontario. But here it is. It says, okay, I want you to divide the residue into as many equal shares as are necessary. And if I have a child who's alive, set up 1 share for them. The child fund trustee is going to be the trustee, so my trustee, until they hit 25. And then they're going to resign, and my child's going to be the trustee when they're 25. And then it's a discretionary trust. And it means the child, here are the beneficiaries, that child, the issue of that child, and the spouse of that child, except during any period when the spouse is separated from that child. And so we've got a discretionary trust for each of the kids. And so that's basically how you do it, how you would do a separate trust. Why would you do that? In the old days, we did it so that you could sprinkle income. You might still be able to do that to some degree. Creditor protection. Those are the reasons why. Of course, there are downsides to trusts, which are tax filings. This trust for any income that's not distributed is going to be taxed at the highest marginal rate. It's more complicated. Accountings have to be kept for each trust, things like that. So there certainly are reasons why we wouldn't do it, but that's how you do it in eState. And so more complicated. Make sure if you're doing something like this, that you obviously review everything, but tell the client this is more complicated and we're going to charge you accordingly. Even though it might not take that long to do it in drafting, using eState, you still want to be paid for the effort and the thought and all of that. So that's really what I wanted to talk about using pooled trusts. It doesn't have to be children; it can be any group of people, and you can do it that way. So, anybody have any questions first about pooled trusts? And then I'll get to any questions on other issues about hodgepodge or otherwise. Anybody use a pooled trust in eState or done a pooled trust before? They're not that common, but they are a good option in some cases, especially with young kids at different stages of life or different needs. All right. Feel free to post it in chat if you don't want to unmute and speak. But there was a question here that do you use hodgepodge to adjust for one or more children receiving life insurance proceeds, etc.? Yes, if I'm giving, again, I'm not a huge fan of dealing with different assets differently, like RSPs or life insurance, and then trying to hodgepodge it back into the residue. It makes things confusing. It makes it more complicated. There are different tax implications. So be careful about that. You could use it for sure. You can adjust based on what they've received from other, an inter vivos trust, maybe, right? Another parent. There's all kinds, you could adjust for any reason you want. You just have to be very careful when you're drafting that kind of hodgepodge clause, that it's clear and as to what exactly is going to be, hodgepodged in essence, especially with registered plans and RSPs. So, unless there's a great reason to do it differently in those with specific assets as opposed to just dealing with it on the same terms as the residue, yeah, that would be certainly my preference. Any questions on anybody have any questions on how to do something in eState or anything that I can help with as well? Yeah. So good question, Monica, about what do you do with those assets where there are assets that are owned by a corporation? So typically, if I had, like, let's say here I have Springfield Inc., okay? Let's say it owned a bunch of different things, life insurance, for example, properties, things like that. Typically, I only list the shares, which is all that really the client owns in this. They don't own the underlying assets of the corporation. And so I don't list them separately. In fact, when clients list them separately, like the Springfield Inc. bank account and I remove those and just put notes in the detail thing, owns a million, life insurance, bank account, X dollars, and whatever else. And that's how, at least how I get to the value. Now, there are cases where a client says, but what happens, I want this property that I don't own, that's owned by a corporation that I control, and I want it to be dealt with in a certain way. That's right. So client owns 100%, but they need to leave a trust for the home that's owned by the corporation for some person. Basically, what I would do is then create a separate asset of the home or whatever asset that's the underlying corporate asset. I'd make sure it wasn't valued in the value of the corporation. Let's just say it was another farm. Okay. And I would say here, I'd say farm, owned by 123 Springfield or something. Just so I've made a note of that. I put that maybe in details as well. When eState isn't going to be able to draft that specifically, it's going to put in a legacy for the farm going to wherever you want to give it. So you give it, like in this case, you give it to the farm, which is owned by Springfield, you give it to Bart, okay? Let's say as an example. What you're going to need to do is draft a clause that says, I direct my trustees to elect directors of the corporation that will, achieve this. Because, again, the client doesn't own the farm. The company owns the farm. The company is run by the directors. He's no longer a director when he dies. Now eState does automatically, and I'll show you this clause that it does automatically. And I'll just show it to you in multiple wills, I think is the one. But it'll put in a clause that says, if I've made any gifts of assets that I don't own but are owned by a corporation, I direct my trustees to take steps to make sure that those gifts are perfected. So let me just see if I can find that clause just so you can see it. Right here. So this will automatically get populated. And it just says, directed my trustee to take certain actions, such as a gift or transfer in respect of property that's owned by owned or controlled by a corporation. I'm directing you to take those steps so you affect those provisions. But again, it's a little bit again, I haven't seen a case on point where the trustees didn't take the necessary steps to affect that. But again, you got to just warn the client that, listen, your will governs your shares. When you're dead, it's now going to be your trustees who own those. And that's the chain of command, as it were. Okay. So that's how I would plan for it in eState. I'd create, if there is a special asset that's owned by the corporation, I would create a separate asset, even though it is owned by the corporation, so that I can create the gift that I need to. Hope that helped. Great. Yeah. And these kinds of questions, don't hesitate to use the question mark and get a live chat and reach out to our support team, Michaela, or I'm on there, and you can ask those kinds of questions and we'll get you an answer right away. You don't have to wait till Tuesdays. Anything else? Great. This Thursday, Ian and Suzanne are doing a webinar. And then, and Michaela, I don't know if you know what the topic is, but I believe it's inter vivos gifting and things like that. So, and then next week, not this Thursday, but next Thursday, we have Ali Spinner talk about income inclusion, capital gains, and how that's going to affect our advice that we might give clients. Then the week after that, we have principal residence trusts with Ian LeBain from TD. So we have a great lineup, and hope everybody has a great week, and feel free to reach out anytime. Thanks, everybody.